FTX founder Sam Bankman-Fried is seeking the right to transfer FTX's crypto despite his ousting as CEO. And the Department of Justice claims SBF tried to influence witness testimony and is asking for a communication ban. All right, joining us now to discuss is Dov Kleiner. He's a partner at Kleinberg Kaplan, Wolf & Cohen. Dov, great to have you on the show. So lawyers for the bankrupt crypto exchange founder, Sam Bankman-Fried of FTX, say that there was no evidence of restricting his access to crypto held by FTX as part of bail conditions in a fraud trial. Should he have access to crypto on FTX?
First of all, good morning, and thank you for having me on. Yeah, it seems actually kind of surprising that he's asking for access to assets which, by all accounts, seem to be the product of misdirection and may involve customer funds, and that's currently being investigated by the DOJ, the SEC, the CFTC, and the debtor estate. And so it is hard to see how he would be permitted to move those funds around.
Yeah, so what grounds does he have for trying to ask for these funds and having access to transfer them?
It never hurts to ask.
Okay.
But like, is there some strategic move in all of this?
One thing is he obviously people have a right to defense, and so part of what I think he's asking for is the ability to use funds for his own defense. And there's going to be issues about insurance policies and how that's going to be used to defend him and frankly others from FTX for the events that happened leading up to November. And so that's part of it. And I think, he's going to claim that it's his property and there's no crime that's been shown yet. He certainly hasn't admitted to anything. Other people, including Caroline Ellison, have, but he's not. And so his argument is that he's not done anything wrong. He's been saying all along FTX had been solvent up until the very, very end. And if not for the sudden run on the market, it would have been fine. So I'm sure those are the arguments that he's going to make.
Yeah, but I mean, like, is there anything that can happen if he does actually have a small victory in this thing where they say, yeah, sure, okay, fine. Does he have extra ammunition, if you will, in court ultimately, or is this just sort of like, as you said, why not take a shot? What's the worst that can happen?
Well, I don't know that it gives him ammunition for anything. If the judge would allow him to do anything, it would be on the grounds that nothing has been shown yet, and that just means yet that any crime has been committed and that the crypto assets are the product of that crime. So I think it would be really just a procedural finding that there was no reason yet to restrict him, but I don't think that's anything that's going to have a long-term effect on what the ultimate findings are going to be.
Meanwhile, the Department of Justice. Oh, go ahead, Lawrence.
No, I actually go ahead, because you're probably asking the same question I am about his big mouth.
Well, the Department of Justice is claiming that Sam Bankman-Fried tried to influence witness testimony. Specifically, there are some court documents filed by prosecutors on Friday that allege that Bankman-Fried messaged FTX U.S. General Counsel Ryan Miller on Signal, asking to reconnect and vet things with each other. Is this normal behavior, or is it something that is looked for or frowned upon? Prosecutors are asking for a communication ban.
Well, look, I'm going to answer that question in just a second. But the first part you said, which is this normal behavior? One of the things that's been very interesting about this entire case, frankly, is how vocal Sam has been from the very, very beginning. And he's given numerous interviews. He's writing a Substack. He's been tweeting, and that's something defendants normally don't do. And it's unusual, and there's a reason for it. And there's a reason why lawyers generally tell their clients, once they're in that situation, to really say as little as possible. Really, nothing good can come from it. And the real danger for someone like Sam is that he is now publicly stating his version of the timeline. And he's not going to be able to walk any of that back. And he's putting that out into the public record. So it's sort of strange that he's been making all of the public statements he's been making. Obviously, he is trying to convince people that FTX has been solvent, and the only reason there are all these issues are because a bunch of things precipitated a run and sort of exposed holes that otherwise would have been filled in the ordinary course. And so that appears to be what he's been trying to do, but it really is dangerous for him because all of those statements are going to get used, as the investigations continue.
Yeah.
As for the particular claims that happened over, I guess it was Friday, when the DOJ sent a letter to Judge Kaplan, and I believe yesterday or Saturday, SBF's lawyers responded, and I think they have to today to file a formal response. The charge there is that he's been speaking to witnesses. There's kind of two charges. One, that he's been speaking to witnesses, particularly Ryan Miller, who is general counsel at FTX, and in some way tampering or trying to interfere with them. And the other is that he's been using Telegram, which is kind of an ephemeral communications service, so that there's no trail. The messages are encrypted and then disappear. And the argument there is that that his bail terms be changed. And so what he's done now, he's been permitted to do, with the exception of witness tampering, which I'll get to in a second. But just reaching out and talking to people was something he had been permitted to do under the terms of his bail order. And the DOJ is now saying that be restricted, that he not be allowed to speak to any employees of FTX at all, other than close family members, without counsel present. And second, that he not be allowed to use Signal or the like. Maybe it would be Telegram as well. But any messaging app where there's no record. That's pretty. The second part in particular is pretty unusual. Not being allowed to talk to witnesses is not an uncommon feature of bail terms. You probably know, and you've heard the phrase witness tampering. Witness tampering is a crime. That obviously is not just talking to a witness, it's trying to get them to change their testimony or to lie or to do other things. And it's not clear, and the DOJ didn't say that. They didn't say he was asking Ryan Miller to lie. But the concern was that he would be using influence he may have had in the past as their employer, as somebody who's frankly helped them, make lots of money, to somehow influence what they say in the case. And what I think the real issue the DOJ would be concerned about is, people kind of coming together with a story as to what happened when that is not in line with their view of the facts and maybe make it harder to build a case. So I think that's what they're concerned about. And we'll find out today SBF's formal response. My guess is they will try to strike some middle ground, maybe. I think the issue about, and I can't say that I'm an expert on this particular topic, but the issue of restricting kinds of communication seems a little bit odd, because they're not saying he can't use Telegram to talk to just witnesses. They're asking that he not use Telegram to talk to anybody at all, meaning you can't use the app, can't use that kind of communication. And that seems a little bit unusual, but we'll see how that turns out.
And it seems that all of these problems stem from just him opening his mouth constantly. If you're his attorneys, do you walk away from this and just go, look, I can't deal with a client shooting me and himself in the foot all the time? Or, is this can't be a strategy from his defense attorney, correct? There's no way in hell, pardon my French, that somebody would possibly say, this is a good idea, Sam, go on Substack, reach out to your friends that worked at FTX. What the heck is going on?
Yeah, so I'm not in the room with them and his attorneys, so I can't say for sure. But yes, I would be surprised if that's the advice that they gave him. I'm fairly sure that they've told him to really lay low and not say much, because, as I said, and we all know what those Miranda warnings sound like, and this is not that. But anything he says can be used against him, and it doesn't help him at all. I'm not sure why he thinks waging a public fight is to his benefit, because right now right now his freedom is on the line, and he's facing jail terms, and that's got to be the most important thing, and putting that at risk by making public statements, which he might be believed to be true, but may be used to build a timeline or a record that hurts him, can't be in his interest. I don't think that that's something his lawyers are going to walk away from him for. He's not lying to people. He's not doing things that I think would be, as far as I know, right? I don't know that he's creating an ethical obligation or problem for them. Which is certainly something that they would consider if they would be concerned about if that's what they thought. But I think lots of lawyers have foolish clients or clients who kind of make mistakes, and I don't think that's a reason to abandon your client.
He's certainly trying something new. Dov, thank you so much for your insights. That was Kleinberg Kaplan, Wolf & Cohen partner, Dov Kleiner.